Welcome to This Explainer. If you've ever stared at a blank screen during a torts final, totally paralyzed, wondering exactly how you're supposed to structure your answer to squeeze out every possible point, well, you are in the right place. We're going to dive into the exact blueprint for transforming your substantive legal knowledge into high-scoring essays.
Because honestly, this right here is the million-dollar question. Are you analyzing or are you just reciting facts? This is the crucial dividing line that separates the panicked fact dumpers scoring a 60 from the precision legal analysts who consistently pull in those 70-plus scores. You know, a lot of students know the law, and they definitely know the facts, but they just totally fail to connect them. Today, we're fixing that.
Today's blueprint breaks down into 5 straightforward steps: interrogating the interrogatory, avoiding the checklist essay, the golden rule of IRAC, mastering the mini IRAC, and finally, deep 3-part analysis. Let's jump right in.
Step 1. Interrogating the interrogatory.
Look, before you even glance at the fact pattern, you need to decode the actual prompt. If the interrogatory says, discuss Lisa's potential claims against Sally, you can stop right there. You immediately know your boundaries. You have one plaintiff, Lisa, and one defendant, Sally. This is absolutely crucial. It acts like a lens. When you go back to read those dense paragraphs of facts, you only care about actions where Sally actually did something to Lisa.
Step 2. Avoiding the checklist essay.
Okay, so you've got your parties. Now whatever you do, please avoid the dreaded checklist essay trap. That's where you just word vomit every single rule you've ever memorized, hoping something sticks. Instead, you need to practice fact anchoring. This means you firmly anchor your analysis only to what the facts actually suggest. Raising issues without a specific factual trigger, that yields literally 0 credit and burns up valuable exam time.
Think about it like this. If the facts show Sally getting angry and swinging a pool cue at Lisa, well, that screams assault and battery, right? It does not scream false imprisonment. It definitely doesn't mean trespass to land, so do not waste your time running through those other torts just to show the grader how well you memorized your outline. Be targeted. Only discuss the torts responsive to the facts you're given.
Step 3. The golden rule of IRAC.
With your targeted issues perfectly anchored, how do you actually put this on the page? Well, you use the golden rule. For every single discussable tort between Lisa and Sally, you create a dedicated section with exactly one issue, rule, analysis, and conclusion. One IRAC per tort per pairing. It is incredibly organized, and trust me, it makes it so easy for graders to just hand you points instead of untangling a chaotic web of legal theories.
Step 4. Mastering the mini IRAC.
But what happens when you hit a really complex element within your main IRAC? You definitely don't want to write a giant, unwieldy paragraph. Instead, you zoom in. You use a mini IRAC. This is a total game changer. It lets you brilliantly subdivide tricky requirements, like you could mini IRAC whether an act was a voluntary act, or what the specific standard of care should be. You could even walk step by step through the strict requirements for bystander and IED under Thing v. Lechusa, treating each of those elements as its own mini issue.
Let's ground this with a concrete example from the source material regarding premises liability. Imagine 5-year-old Johnny. He's trespassing on Harold's lawn, and he finds an unlocked, highly toxic pesticide canister. Now, the overarching issue is negligence, sure, but a major sub-issue we need to mini IRAC is the duty of care owed to a trespassing child.
Using the mini IRAC steps here forces you to methodically explain that exact standard under the attractive nuisance doctrine. Then, in your mini analysis, you'd apply the learned hand formula. You explicitly spell out that the burden, just putting a lock on the canister, was practically 0. But the gravity of a child getting chemical burns, totally catastrophic. Structuring it this way proves to the grader exactly how that duty was breached, piece by piece.
Step 5. Deep 3-part analysis.
For our finishing touch, we have to transition from just reciting facts to the deep analysis that gets you top scores. Check out this sentence. Dye breached his duty because he was driving 20 mph over the limit. This right here? Classic 60-level fact dump. It tells us what happened, yeah, but it completely fails to explain why it legally matters. The grader's just sitting there asking, okay, but why does speeding equal a breach of duty?
To break into that 70-plus range, you've got to use this 3-part formula. Make an assertion, give the supporting facts, and then deliver the legal why. You have to unpack the precise reasoning.
Let's apply this to negligence per se. You can't just say, Dye broke the law by speeding. No way. You have to connect the speeding driver hitting Pat in the crosswalk to the specific class of persons and the type of harm the statute protects. You explain that the law was literally designed to protect pedestrians, like Pat, from getting hit, which establishes the standard of care and the breach all at once. Seeing these side by side really drives it home, doesn't it? The 70-level deep analysis doesn't just parrot the prompt, it applies the specific legal test to those facts to yield a reasoned conclusion. It's night and day.
Now, what if you want to push for an 80? Well, you have to find the gray areas. When you're outlining, put asterisks next to the close call facts. Then, in the essay, argue both sides. Give the plaintiff's best argument, then hit them with the strongest counterargument for the defense. And finally, and this is key, definitively pick a lane. Actually, scratch that. Don't just pick a lane, explain why it's the better approach. Graders want to see your legal judgment, not fence-sitting.
So, if there is one thing you take away from this entire explainer, it's this quote right here. You absolutely cannot stop at the facts. You must deliver the total package. Your analysis is the bridge between the messy real-world events of the prompt and the rigid structure of the law.
I'll leave you with this question. When you sit down for your next practice exam, are you going to build a precise legal analysis, or are you just going to dump facts? Take this blueprint, apply it to your next set of interrogatories, use that golden rule of IRAC, and just watch how quickly your scores start to climb. Don't let your hard-earned knowledge go to waste on a poorly structured essay. Thanks for joining me, and I'll catch you next time as we keep breaking down the complex into the understandable.